Oh, oh, we up. We up. Grand rising in this thing, huh? Grand rising in this thing, huh? It's a beautiful, beautiful day. Glorious. So happy to be alive. We're in one of the best times to be alive in our lives and history, straight up, if we don't destroy ourselves. But we're getting smarter and smarter and greater every day as we become or as we know who we are. I'm so blessed to be here. So thankful to have y'all here today. Nick, we don't say morning. We ain't morning nothing. We are rising. I see this. Look at this. Grand rising. He knows. We don't mourn nothing. We rising in greatness every day. I'm going to tell y'all something. It's been a little bit since I've been able to do a live stream and go through something as beautiful as this. I'm actually really happy. Last night I was working very late, very tired, literally falling asleep as I'm talking. But we developed something great for Kansas. Not just Kansas, the rest of the nation. It's beautiful. It puts everything in place in a perspective that we all should know. We all should cherish. So I want to shout out everybody. What's up, Nick? What's up, Dis? What's up, Wasamata You? What's up, Jen Set? What's up, Laserific? What's up, Christopher? And what's up, Bucking Up Tyrants? My boy Bucking Up Tyrants over in Germany. Stay safe over there, brother. Question comes from Christopher. Hello, Cameron and the gang. What platform do you all use? Not exactly sure what platform you mean. Maybe be a little bit more specific. We use quite a few, I tell you. This one, we're going to have a lot of fun. Y'all are going to be like, what the hell, Cameron? I swear you are. I swear y'all are. So if you don't know, my name's Cameron. This is Power Inherent in the People. We go through a lot of cool things. We learn as much as we possibly can about who we are and how to enforce who we are. Hope you're doing good, Carlton. Grand Rising, everybody. All right. So let's get into this one. This one is going to be a notice and demand. All right. Notice and demand. Let me see. Entire screen. Okay. Entire screen. I think I'm doing this right. I don't know. I'm going to have to this over. Y'all bear with me. Give me 1 second. It's been a while since I did a live. All right. It's been a while. Now, if you don't know, you can all come to piitp.com/Wisedome. That's WISEDOME. And you can join up to Operation Wisedome. Of course, we have meetings every Wednesday and every Saturday. Again, we're a group. And then, each session in our meeting is 3 hours plus. Literally 6 to 8, honestly. You get full access to the Discord, discounted consultations, and then, of course, all the exclusive document content and access as well. So let's get into it. All right. So this last night, I was working with my boy Quentin, and we were working on a notice and demand, and he wanted to include some aspects of judicial notice, and it was just a certain section that he really, really liked. And we were having some problems with his thread initially. And so we were like, all right, well, let's rework the thread here. And we opened up a new thread, brought in the information, and we came popping out with this, right? So we got to work, and this is what we created and developed. Will he use this 57-page notice and demand? I'm not sure, but yes, this is a 57-page notice and demand. Okay. And it's a notice and demand to dismiss as unconstitutionally applied with judicial notice. Now, why are we doing a notice and demand as unconstitutionally applied in the first place? Well, because there's two different aspects now of a body of law in which they're all out here working on. You got the Constitution aspect, then you got the statutory. Which one you want to be under? You want to be under statutory? You want to be under Constitution? I want to be under Constitution. So I'm hitting with a notice and demand as the statute was unconstitutionally applied to me or to him. So we're bringing ourselves into an aspect of saying, okay, I'm not going to play with you in regards to what's body of law, what framework we're working from. So instead of a motion to dismiss, okay, we're hitting for a notice and demand to dismiss. We're enforcing it. So let's get into it. Of course, in all of our documents, We're creating a table of contents to give them the aspect of where they need to be if they're looking for something specific. But yes, this is a 7-page document or notice and demand. It's the biggest and the best we've ever created. I'll tell you that right now. So we're always starting off our documents with a notice of special appearance and jurisdictional challenge. Every single one of them. And the reason being is because we, again, got to put them on notice of certain things that we're invoking so we don't have complications on that back end. Again, invoking things, bringing them into the court is so important. That sets the ground layer. It sets everything in place. So this is a comprehensive notice and demand, and it constitutes a special appearance, not general for limited purposes, but for challenging the jurisdiction in personam, number one, in rem, number two, and in subject matter, and establishing the record for constitutional rights violations pursuant to the principles articulated in Ex parte Young in 1908 and Hale versus Hinkle in 1906. And all of our creator endowed rights are reserved. I'm reserving them all. Nunc pro tunc, now for then. And this notice and demand is submitted with explicit reservation of all rights pursuant to the Kansas statutes, subsection 84-1-308. Most of y'all, I don't know if y'all know this, but UCC 1-308 is codified in most states. Go find it and use it. If they say, oh, that UCC don't apply here, well, it sure does because it's in your statute. It's codified. Go ahead and pull the code up for them. And the doctrine of sine qua non, which is without which not. This sovereign individual appears sui juris and in propria persona, asserting the inherent unalienable creator endowed rights that predate and supersede all governmental authority. All governmental I supersede. My creator endowed rights supersede and predate anything that you want to bring forth upon me like you just got some power over your boy. As recognized in the Declaration of Independence and codified in the Constitution for the United States of America. Yo, if everything's sounding okay, y'all let me know. Y'all give me a shout out in the chat if we're sounding good and everything's working properly. Please let me know. Hopefully I'm not lagging or just everything's good. I have no clue. Section 1. That mandatory judicial notice pursuant to KSA subsection 60-409. All right, y'all, let me know. Are we frozen up? Are we good? Somebody in the chat, let me know. Are we rolling? I don't know if I'm lagging, if we're holding steady. Good deal. Appreciate y'all. So pursuant to the mandatory provisions of KSA subsection 60-409A, this honorable court shall take judicial notice. Judicial notice is a very big thing without request by any party of the common law. What? Constitutions and public statutes in force in every state, territory, and jurisdiction in the United States of America, and of such specific facts and propositions of generalized knowledge as are so universally known that they cannot reasonably be the subject of dispute. You ain't finna dispute the aspect that I'm invoking common law. You got to take judicial notice right here and now. Additionally, pursuant to KSA subsection 60-409C, this court shall take judicial notice of the matter specified herein upon the request of the defendant, and sufficient information has been furnished to enable a proper compliance with this request. You hear me? With this request, as sufficient information has been furnished, I'm giving you the information. I'm enabling you to make a proper compliance with my request. And notice has been provided to enable any adverse party, the state, to prepare to meet this request. If you ain't ready for my 57-page request, if you ain't ready to meet that, and in the detail and depths in which I go into in relation to my creator endowed rights, then just go ahead and nolo prosecute. Just go ahead and nolo prosecute. There ain't nothing to argue about. We don't need to go tit for tat. If you can't tit for my tat, I'm coming. I'm slamming. You on play pickleball with me? I will show you how this works. You dig what I'm saying? Uh-oh. I forgot to, let me see. We got to do the focus. Do not disturb on. Okay. Now, under the mandatory provisions of KSA subsection 60-409A and B1, this court is required to take judicial notice of the common law. You gonna take judicial notice of the common law and constitutional principles enforced throughout the United States. The accused, appearing as a sovereign individual and one of the people, respectfully demands that this court take judicial notice of the following fundamental legal principles. 111A, primacy of common law and natural rights. The common law remains in full force and effect in Kansas and governs where not explicitly repealed by statute. Show me where it's been repealed. Show me where it's been repealed. This common law foundation recognizes that fundamental rights derive not from the governmental grant, but from the Creator as acknowledged in the Declaration of Independence and codified in the Constitution for the United States of America. The principle of naturale, natural law, establishes that certain individual or certain rights are inherent in human nature and cannot be legitimately abrogated by positive law. These Creator-endowed rights include, but are not limited to, the right to life, liberty, property, happiness, and the pursuit of happiness, as well as the fundamental right to travel freely without governmental interference, absent compelling justification. Do you know what absent compelling justification means? You have to really be interested in saying, that makes me, I'm not even sharing my damn screen. That makes me so worried, and it shocks the conscience that I want to get involved with this situation. You know, where you see a situation and it's so much for you, just like, bro, I have to get involved and help somebody in this situation. That's the only time the government needs to and must and shall and can, to be honest with you, interfere with your life, your liberty, and your happiness, including your property. B, the constitutional supremacy and judicial review. A statute repugnant to the Constitution is void ab initio. Well, damn. There it is right there. There ain't nothing else really to it. But apparently we got to get the logic back in our nation. And that's fine with me. I'm helping. And cannot be enforced by any court or governmental entity. So why aren't we bringing it up? This principle of constitutional supremacy requires that all governmental action, including law enforcement activities, conform to constitutional limitations. Yeah, you got limitations, buddy. And respect the Creator-endowed rights of the people. And what? Respect the Creator-endowed rights. That's all we've ever been asking throughout all time in history. Am I right or wrong? The doctrine of judicial review imposes upon courts the solemn duty to scrutinize governmental action and declare invalid any conduct that exceeds the constitutional boundaries. Doesn't mean agree with it or, oh, well, I'm dismissing yours for right now and I don't want to hear it. You got a duty to do it. You got to do a ministerial duty at that. This duty is particularly acute when governmental officials act ultra vires beyond their lawful authority in violation of clearly established statutory and constitutional limitations. See, they go beyond their lawful authority all the time because they are always presuming, because the state says you're required. It's mandatory that you have a driver's license. Bro, again, if administration of a free man is repugnant to his freedom, so I cannot be required to do anything. I'm sorry. Get it right. C, the judicial neutrality and due process requirements. Now, judicial neutrality and fundamental fairness are required in any proceedings implicating liberty interest. This requirement extends beyond mere procedural compliance to encompass substantive fairness in the application of law and the protection of the Creator-endowed rights. The principle of adi alteram partem, here the other side, requires that courts provide meaningful opportunity for the assertion and vindication of constitutional rights. So if they ain't even giving you the opportunity, they have failed. You understand that, right? If they haven't even given you the opportunity, they have failed. Now, why is this? Like, let's say I'm trying to have my right to speak and I'm getting cut off and we ain't trying to hear it. Bro, you're not giving me my opportunity to assert and then also vindicate my constitutional rights. Can't happen. Null and void. Take it on up. This includes the obligation to consider, duty to consider challenges to governmental authority based on the statutory and constitutional violations, which is what all of this encompasses. Notice and demand to dismiss as unconstitutionally applied. The judicial notice of the Creator-endowed right to travel. Now, the right to travel is a well-settled liberty interest under both constitutional and common law, deeply rooted in the natural law tradition and recognized as fundamental to human dignity and individual sovereignty. This court is required to take judicial notice of the following established legal principles. Again, this is what we would file. This is something I would file into the court. Notice and demand. This court is required to take judicial notice of the following established legal principles. There is no question to this. What's up, Thomas? What's up, DLM MLB? What's up, Donnell? Uh, what's up, Mr. Osgood? I'm sure April with you too, Thomas. What's good, y'all? What's up, Andre? What's up, Carlton? Yeah, man, I see y'all in this thing. The right to travel is an integral component of the liberty protected by the 5th and 14th Amendments to the Constitution for the United States of America. This right encompasses both interstate and intra state movement and extends to all forms of locomotion, including travel by private automobile on public highways. The Supreme Court has consistently recognized that the right to travel is fundamental and cannot be arbitrarily restricted by governmental action. This recognition reflects the understanding that mobility, the movement, right? If I want to get up and move, right? Like right now, I'll get up and move, right? I'm moving, right? I'm shaking. I'm baking, right? Shaking and baking. Ain't nobody gonna come in here and tell me stop moving. You get what I'm saying? That's not gonna happen. Just like on my roads, you're not gonna do that either. Period. You're not. No. Turn this back down. Natural law foundations of travel rights. The right to locomotion is a fundamental liberty at common law, predating the constitutional recognition and deriving from the natural law principle that individuals possess inherent freedom from movement. This natural right cannot be converted into a crime or subjected to arbitrary governmental regulation without compelling justification and then the due process of law. The distinction between the creator-endowed right to travel and commercial use of highways is a fundamental to understanding the scope of the governmental regulatory authority. Private travel for personal uses, sorry, I'm over here doing this again, reading my face, excuse me, falls within the protected sphere of individual liberty, while commercial transportation is subject to that reasonable regulation under the state's police power. Free travel, point A to B. Commercial, I'm using the roads for profit. A constitutional right may not be converted into a crime through legislative or executive action. Right here, where's the footnote? Shuttleworth versus Birmingham. Shuttleworth versus Birmingham. A person faced with such an unconstitutional licensing law may ignore it and engage with impunity in the exercise of the free expression for which the law purports to require the license. Do you hear that? Do you hear how long ago it has been established? Shuttlesworth versus Birmingham. Okay, in 1969, that good old 666, that duality there. A person faced with such an unconstitutional licensing law or scheme may ignore it and engage with impunity in the exercise of the right of free expression for which the law purports to require the license. If you violate my right in any way from your illegal licensing scheme and scan, I will hold you liable. Period. I ain't gonna put up with it. Ignorance is no excuse to the law. And I ain't gonna put up with it with any of my friends either. Where's that footnote 15? This principle applies with particular force to the creator-endowed right to travel, which cannot be criminalized through traffic regulations that exceed constitutional boundaries. Thank you. The exercise of a constitutional right cannot serve as the basis for criminal prosecution, and any law that purports to criminalize such exercise is void ab initio from the beginning. That's coming from 16. We see it right here, the footnote, Murdoch versus Pennsylvania. Okay, 1943. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution. We comprehending, right? This isn't, no, you're required to do this, and my police are going to do whatever they want to do to you, and you will abide by the presumption and assumptions in which we think we have authority over you. No. Grand Rising, Sonny. Hope it's feeling nice and pleasant out there in Florida. Skyhopper, I see you in this thing. What's up, Slash Shaw? My boy. Beautiful Julie. Hey, Julie. How you doing, girl? This principle requires careful scrutiny of the traffic enforcement actions to ensure they do not impermissibly burden the fundamental right to travel. Now, this court is required to take judicial notice. Again, is required. Why? Because I run this, you run this, we run this. As long as you don't hurt nobody, you commit a crime, bro, you out of there. I don't know what to tell you, bro. It's what it is. I don't deal with criminals. I don't like you if you're out there committing crimes. Okay. I like you if you're out there living true, staying true, uplifting God's laws. Of the following principles governing the necessity, defense, and lawful arrest procedures. Number one, the A statutory necessity defense. The necessity defense is codified at KSA subsection 21-5205, which recognizes lawful justification to prevent greater harm. This defense applies when governmental action exceeds lawful authority and threatens greater harm to individual liberty than would result from resistance to such unlawful action. The necessity defense encompasses both the right to resist unlawful governmental action and the obligation. You got a duty to prevent violations of constitutional rights. This principle recognizes that individuals have not only the right, but sometimes the duty to resist governmental tyranny and protect creator endowed rights. It's like anytime we see somebody out there doing something wrong to somebody, and in your mind you see it and you're like, I can't stop. I can't keep going. I have to stop to help this person. That's an internal duty, right? That's an internal knowing within. That's like that God spark. That's perspective I'm talking about when I say that each and every one of us has a spark of God within them. Each one of us is God in that aspect. Why? Because God is everything. You are God. If I'm looking at you in the eyes, I am looking at God and God is looking at me, because we all are a part of the great I am. I respect that. I understand that. I comprehend that. It is not very hard to comprehend. And with that comprehension, that makes me greater. I'm telling you, all I care about is showing gratitude to the great creator and thanks for this life. This principle recognizes that the individuals have not only the right, but sometimes the duty to resist governmental tyranny and protect creator endowed rights. Maybe now you have a better comprehension of what my mission is and why. Again, this is the necessity defense, and it is codified for all you Kansans in KSA subsection 21-5205. Okay. Due process requirements for valid arrests. Arrest without sworn complaints. Without. Okay. Affidavits. Okay. Or findings of probable cause violate the fundamental due process requirements. It's coming out of State versus Shirley in Kansas in 2004, which is establishing that due process requirements for valid arrests and the necessity of proper procedural safeguards. Wondering if they're always out there figuring out if they got those proper procedure safeguards or not. The absence of these procedural safeguards renders any subsequent prosecution fundamentally defective and violative of the creator endowed right to due process of law. That means we're coming after the prosecution then, huh? The requirement of sworn complaints reflects the fundamental principle that governmental power must be exercised within the legal constraints and subject to judicial oversight. The absence of such procedural compliance indicates governmental action ultra vires and in violation of constitutional limitations. I just want you to be aware, too, if you're not noticing, that almost every other sentence, if not, we're having footnotes that back up every statement that we're making, okay? We ain't out here just throwing to see what sticks, okay? We're out here with citings, okay, references directly to everything that we're bringing forth. Fourth Amendment protections against unlawful searches. VIN inspections or physical interference with private vehicles without a warrant, consent, or plain view exception constitute unconstitutional searches in violation of the Fourth Amendment. So let's say I had this flag right here, right? I had this flag in my car and it was covering up the VIN, okay? And they came in my car illegally and pulled that off and looked at the VIN. That's a violation of the Fourth Amendment. That simple thing is a violation of the Fourth Amendment. Such searches violate the creator endowed right to be secure in one person's papers and effects against unreasonable government intrusion. The physical inspection of vehicle identification numbers constitutes a search within the meaning of the Fourth Amendment and requires either a warrant based on probable cause or the existence of recognized exceptions to the warrant requirement. The absence of such justification renders any evidence obtained through unlawful searches inadmissible under the exclusionary rule. Yes, we're talking about that exclusionary that roots back to the fruit of the poisonous tree. Okay? Yeah. Yeah, man. Yeah, man. Yeah, man. Request for formal entry into the judicial record. Pursuant to the mandatory language of KSA subsection 60-409A and C, defendant respectfully demands that this honorable court take judicial notice of the above facts, those that we just spoke of, and authoritize and formally enter said notice into the record as a matter of law. These principles constitute the foundational legal framework within which all subsequent proceedings must be conducted and against which all governmental action must be measured. The failure to take judicial notice of these well-established legal principles would constitute reversible error and would deny defendant of the fundamental right to have his case adjudicated with proper constitutional and statutory framework. You got that? You seeing what judicial notice does? You seeing how we're bringing what we want to bring in stand? How it must be entered into the record as a matter of law? And how they must take judicial notice of the facts and authorities. You can't get past these authorities. And there won't be no excuse to say you didn't know about them because we're bringing them in. Judicial notice. The principles set forth herein are not matters of dispute. I ain't going to dispute them, just like I be telling them when I be out there talking to chiefs or any officers. This isn't up for dispute. This isn't up for debate. I'm not going to argue with you something that's already known, homeboy. Ignorance of the law is no excuse for you, not me. Get it right. But are fundamental to the American legal system and the protection of the creator-endowed rights. In the interest of the judicial efficiency, the constitutional compliance, and the timely resolution of this matter, a formal ruling on this request. Yeah, you hear that? A formal ruling on this request and demand for judicial notice is respectfully requested by no later than August 6th. Better answer. That's how it goes. Not finna argue about it. Period. Now, we've gone through that initial judicial notice. We're moving on to the second part of the document of this notice and demand as unconstitutionally applied, which is 57 pages. So if you're just now joining, welcome. We just went over the judicial notice aspect of this part. Now we're going into an introduction and summary of the argument. Again, this isn't no sovereign citizen thing. This is literally law. This is legalese here, y'all. I don't know what else to tell you. You're just going to have to accept it for what it is. Okay. Let me see something real quick. Okay, good to go. All right. So a sovereign individual and man and living man, one of the people, endowed by his creator with certain unalienable rights, appearing in propria persona in sui juris, and respectfully moves this court, honorable court, to dismiss with prejudice all charges and citations filed against him, and for comprehensive declaratory and injunctive relief, pursuant to KSA subsection 60-212B1, for failure to state a claim upon which relief can be granted. KSA subsection 60-212B6, failure to join a party under KSA subsection 60-219, and KSA subsection 60-212C for lack of subject matter jurisdiction, and the constitutional guarantees of the 4th, 5th, and 14th Amendments to the Constitution of the United States of America. This case presents a constellation of fundamental questions of statutory interpretation, constitutional law, and natural rights that strike at the very heart of individual liberty, the limits of governmental power, and the sacred relationship between the people and their government. This is a good question. Are y'all ready for it? Can law enforcement officers arrest individuals for traffic infractions when Kansas law explicitly prohibits such arrests? Can governmental officials act beyond their statutory authority with impunity? Can the creator endowed right to travel be converted into a criminal offense through arbitrary enforcement actions? The answer is as demonstrated by clear and unambiguous language of Kansas statutes. So we ain't even talking about federal law at this point. We're talking about Kansas statutes. Controlling constitutional precedent we will bring in and fundamental principles of natural law are emphatic and unequivocal no. And that's a big no. And we're going to go through the proof right now. The Kansas legislature, in its wisdom and recognition of the fundamental creator endowed right to travel freely without governmental interference, has established a bright line rule that protects citizens from the overreach of governmental authority and traffic enforcement. KSA subsection 22-2401D states with crystalline clarity and admits of no exceptions, quote, any crime except a traffic infraction or a cigarette or tobacco infraction has been or is being committed by the person in the officer's view. This statutory language creates an absolute, categorical, and non-discretionary prohibition against warrantless arrests for traffic infractions. Let's go back. Rewind it. This statutory language creates an absolute, categorical, and non-discretionary prohibition against warrantless arrests for traffic infractions, recognizing that such infractions are civil violations, not criminal offenses warranting the deprivation of liberty through the arrest. Furthermore, the Kansas legislature has mandated. You remember when y'all got the mandates when they came around with that mask stuff? He never mandated me, though. I'll tell you that much. They're mandated, though, because they chose to work in a public servant capacity. So the Kansas legislature has mandated a specific exclusive procedure for handling traffic infractions through KSA subsection 8-2106A, which requires, they're required. They always say, oh, well, you're required. Bro, I ain't required to know. You keep talking to the, you keep talking to one of the people is, bro, who are you talking to? Chill. Which requires, they're required though, quote, shall issue a written notice to appear in court and, quote, release the person from custody upon personal recognizance or upon the person's written promise to appear in court, unquote. This mandatory procedure reflects the legislature's recognition that traffic infractions do not warrant the extraordinary governmental power of arrest and that individual liberty must be protected from arbitrary governmental action. Yet, in flagrant violation of these clearly established statutory prohibitions and in direct contravention of the creator endowed rights protected by the Constitution for the United States of America, officers of the Butler County Sheriff's Office arrested defendant for alleged traffic infractions, thereby exceeding their lawful authority and violating multiple constitutional provisions. The unlawful arrest was not merely a technical violation of procedure. It was a fundamental breach of the social contract between the people and their government, a violation of the sacred principle that governmental power is limited and must be exercised within the bounds of law, and an assault upon a creator-endowed rights that form the foundation of American liberty. Now, again, I just want my people to know, young, old, police officer, not police officer, all people need to know that you are a creation of the creator. That's number one. Number two is that if you don't hurt another person, no harm can be brought forth against you. And I'm not talking about physical harm. I'm talking about you being taken to jail without even being physically hurt. That's an emotional hurt. That's an irreparable harm. It's a deprivation of your rights, your life, liberty, and the pursuit of your happiness. Okay? You need to understand that most of these things out here that give them power to do what they're doing to you is based on the aspect that you're conforming. You have a contract that you've signed. You've waived your rights for a privilege. I don't know why. Maybe it's because everybody else does, and then you were told, so you believed it, and then you did it. But I don't care who you are. I'm telling you, law enforcement, I have nothing against good cops. I have very big problems with bad cops. And we got cops in here right now in the chat that are watching. They've already commented. My boy Sonny's in this thing. Y'all act like we aren't cool with good cops. Good cops want you bad cops to stop. Just like us good American, people with morals and integrity, and honor, those who stand for freedom and truth, us who have a spirit of William Wallace within us. You dig what I'm saying? I've stated this before. You have to have that heart, that desire Tap into the spirit of the Most High, man. It is not a pride or ego thing. It is a duty that we have, that God has given us as Americans. The constitutional violations in this case are manifold and egregious. The Fourth Amendment to the Constitution for the United States of America protects the creator endowed right to be secure in one's persons against unreasonable seizures. Okay, that's coming out of the U.S. Constitution. Okay, y'all see it. 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. An arrest made without lawful authority constitutes a per se unreasonable seizure that violates this fundamental constitutional guarantee. Do you see how every sentence damn near has a footnote to support what we're saying? We cannot be refuted. We cannot be debated. We cannot be squandered. We will not be quashed. The 5th and 14th Amendments guarantee that no person shall be deprived of life, liberty, or property without due process of law. An arrest made in direct violation of the state statutory law violates both procedure and substantive due process, as it represents arbitrary governmental action that shocks the conscience. Oh, there it is, that term. I told you earlier, when you see something that shocks the conscience, I'm guaranteeing you're getting involved with it. You're going to help that person because it's wrong and exceeds the bounds of lawful authority. The temporal and procedural violations in this case are equally compelling. The Supreme Court in Rodriguez versus United States, this is a big one, established that, quote, a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. That means they cannot extend the stop beyond a de minimis amount of time to sit here and try and figure out all these other questions and where you're going from and what you're doing. Dude, what'd you pull me over for? Okay, here's my information. My name is Cameron James Wilson, 2587. Go write the ticket. That's it. That's it. There is no other license and registration. I don't want to give it to you. Well, you have to. No, I don't. Write the tickets if you want. I'll do it in court. It's none of your business. Write the tickets. I'll handle it in court. You have no power. There's no crime. There's no RIS. You have nothing. Move around. Okay? Leave me alone. Under the Rodriguez analysis, the officer's authority was strictly limited to addressing the alleged traffic infractions through the issuance of citations pursuant to the mandatory procedure established in KSA subsection 8-2106. A. What's wild to me is that this code is 36. You got your 2-1 and then 6. That's my number. It's so wild that all of these numbers consistently are constantly popping up everywhere for me. Just for me, I don't know. So the decision to arrest necessarily exceeded this authority and violated the Fourth Amendment protection against unreasonable seizures. Looks like Butler County is going to have some things to speak about in civil court, or at least in depositions, or at least with their attorney and or attorney general of the torts division. Maybe even the DOJ out there in Kansas, because they don't even, it's like they don't understand clear law. Their own limitations. This case also implicates a fundamental doctrine of ultra vires, which holds that the governmental action taken beyond lawful authority is void ab initio and cannot serve as the foundation for valid legal proceedings. When law enforcement officers act beyond their statutory authority, they lose the protection of the governmental immunity and act as private individuals without legal justification for their conduct. So what do you mean, Cam? What do you mean? You mean when you put them on notice with a liability? When you put them on notice with a notice of liability and they act beyond their statutory authority, they lose all the protection of governmental immunity and act as private individuals without legal justification for their conduct in which you can sue and bring forth litigation? Yes, that's what I'm doing. I'm bringing 1983 cases all up on their ass, boy. Look at the beat stop. I don't even like this one, so you ain't getting one out of me on this one. All right, let's get back to it. This one's okay, but I don't like it that much as well. All right. So the separation of powers doctrine. Right here, second paragraph, right here, line 18. The separation of powers doctrine, a cornerstone of our constitutional system, requires each branch of government to respect the authority and limitations imposed by the other branches. Here, and this one's kind of cool too, because it's like, the line of authority, just real quickly, just for cops, people, brand new people coming to the channel for the first time. The line of authority goes like this: the Most High, the great creator, then man and woman who was made in the image of God. Then we created a government or a societal body to help manage our affairs because we didn't want to have to do it all the time. So we said, you know what, we'll give a little bit of our makings every year, our tolls, our energy, our labor over to others so that they can maintain things that we don't want to have to maintain all on ourselves, right? Just as much as you don't want to clean your house, so you hire a house cleaner. You know what I'm saying? So we did that with the government on the federal aspect. I mean, we had a lot of issues that we had to, but that was one of the main reasons. Then we created, of course, well, we already did, but we have the states, right? Below that. Then you have the counties authority. Then you have the cities. City police are at the very bottom of that authority. You know? So you don't commit a crime, they literally have no authority. So when they tell you, move away or get out of here, or all these crazy demands that they do all the time, just be like, yo, bro, come on, man. Like, why are you trying to tell me what to do? You know you ain't got no power. Chill, dude. Like, be respectful, man. I would never just do that to you while you out and about. Well, okay, calm down, bro. Like, just chill, my dude. You know, you ain't got the power to do that. Calm down. Instead of people, that ain't gonna work. We're gonna have to do it right. Here, the Kansas legislature has explicitly limited the executive branch's authority to arrest individuals for traffic violations or infractions. Excuse me. When law enforcement officers disregard these statutory limitations, they not only violate individual rights, but also undermine the separation of powers by usurping legislative authority and acting in direct contravention of clearly established law. The rule of lenity, ching chong, tried to tell that good old chief yesterday about the rule of lenity. He didn't want to listen. He has no clue. A fundamental principle. He literally, I said, what's a crime? He said, when you break any statutes, that's not how this goes, bro. Or you break any traffic violations, that's not how this goes. Which makes me wonder, how did you become a chief of a whole city, bro, without knowing what an actual definition of a crime is? Damn. Now, I ain't going to go out there and apply for chief of Yakima, Washington. But I will tell you this much. We're going to have to get some education going here. Get the power back to the people. Requires the rule of lenity, a fundamental principle of statutory construction, requires that ambiguities in criminal statutes be resolved in favor of the accused. So let's say there's any ambiguity in the statute in the formulation of its creation or its language in and of itself. Okay? If there is any, it requires that those ambiguities in the criminal statutes be resolved in favor of the accused, meaning they're supposed to be more in favor of you. If there's any ambiguity, meaning that, oh, well, I read this statute and I took it as this, and that ambiguity can be brought forth in an argument, it goes in your favor. However, in this case, there is no ambiguity, and the statutory language is clear and unambiguous in prohibiting arrest from traffic infractions. Bing bong. The rule of lenity, therefore, compels the dismissal of all charges, as the legislative intent clearly indicates that such charges cannot stand when based upon unlawful arrest. Now, the fruit of the poisonous tree doctrine, I got some fruit up in this thing. Do you want some? It's been sour. We dismissing, bruh. Yeah, you know what I'm talking about. Requires the suppression of all evidence obtained through constitutional violations. 35. Let's check out this footnote. What we got? This one's coming out of Silverthorne Lumber Co. versus United States in 1920, establishing that evidence obtained through constitutional violations must be suppressed. Do you understand? Now, I want you to listen to me. Listen to me with the most. Silverthorne Lumber Co. versus United States in 1920 established that evidence obtained through constitutional violations must be suppressed. I'm talking about any constitutional violation. Everything must be suppressed. Everything. Your constitutional limitations, violations are on the forefront. I don't know why we always like, I want to argue my right to travel. Bro, everything is a constitutional violation because they have presumptions and assumptions that you are like everybody else. And you are not. You now know. You know who you are. You are a creation of the Creator. You are not required to do anything other than the duty to be an American, which is uplift others, to help others in need, to stop any crimes as you see them being brought forth on another. Your duty is to uplift others and show gratitude for the great Creator in life. That's literally all you have. Don't violate crimes. You'll be good out there. Since the initial arrest was unlawful and violated clearly established statutory and constitutional law, all evidence obtained subsequent to that arrest, including any statements, observations, or physical evidence, must be suppressed as the fruit of the poisonous tree. Damn, they ain't got much cases when you bring that on in, do they, Papa? Where'd you find that one? The standing doctrine requires that there be an actual case or controversy involving parties with legitimate interests in the outcome. The what doctrine? The standing doctrine. I told y'all we work in doctrines, maxims. I told you we love to work with doctrines and maxims. Requires that there be an actual case or controversy involving parties with legitimate interests in the outcome. So when they say, yes, I'm prosecutor, blase, and I'm here on behalf of the people. What people do you have behind you with a sworn affidavit and complaint stating that I harmed them in any form or fashion? You don't. It's imaginary. Here, the prosecution has failed to identify any injured party or verify complainant who has suffered actual harm from the alleged traffic infractions. The absence of a verified complainant from an injured party raises fundamental questions about the prosecution's standing to bring these charges and the court's subject matter jurisdiction to adjudicate them. The principle of nullum crimen sine lege, nulla poena sine lege. No crime without law, no punishment without law, requires that criminal conduct be clearly defined by law and that there be a legitimate governmental interest in prosecution. Where no party has been harmed and no public interest is served, prosecution becomes an exercise of governmental oppression. Oppression. Rather than administration of justice. You're supposed to be serving me, bro. You're supposed to be administering justice out here on these streets, not out here preemptively looking to impose fines and fees upon me. The case presents an opportunity for this court to reaffirm this case and matter, presents an opportunity for this court to reaffirm fundamental principles of constitutional law, statutory interpretation, and individual liberty that are essential to the preservation of our self-governing Republican form of government. The issues presented are not merely technical legal questions, but go to the heart of the relationship between the people and their government, the limits of governmental power, and the protection of creator-endowed rights that form the foundation of the American liberty. You know, those hundreds of thousands of people that died for us, bro, to make sure that we have what we have. It's like sometimes people be like, "Oh, I don't even go to court. This court system's stupid." It's like, bro, go over to Africa, go over to Saudi Arabia or somewhere. You just gonna get your arm chopped off. Say that. But I guarantee you're gonna appreciate this court system here a little bit more when you start seeing what's up on other countries. You better start appreciating what you got, especially those hundreds of thousands of people that died to make sure you got due process of law. The remedy for these violations is clear and compelled by law. Dismissal with prejudice of all charges. Comprehensive declaratory relief establishing the unlawfulness of the arrest and the constitutional violations committed. Injunctive relief preventing future violations of statutory limitations on arrest authority. Expungement of all records related to the unlawful arrest. And such other relief as justice and the protection of creator-endowed rights required. As the Supreme Court recognized in Ex parte Young, when governmental officials act beyond their lawful authority, they strip themselves of their official and representative character and are subject in their person to the consequences of their individual conduct. Thank you. You will be responsible. The officers in this case have done precisely that, and their legal consequences must follow to vindicate the rule of law and protect the creator-endowed rights of all citizens. The time has come for this court to declare, with clarity, conviction, and unwavering commitment, the constitutional principles that the law means what it says. People cannot be arrested for traffic infractions in Kansas. This declaration will not only vindicate defendants' creator-endowed rights, but will serve as the beacon of justice for all who cherish liberty, constitutional government, and the rule of law. So I wanted to do these first two sections with y'all real quick. Not taking up too much. Do an hour, and then what I will do is I will come back and do a part 2 on this one. Let me check the chat real quick, see what y'all saying. I've not been paying attention. Sorry, y'all. They don't push me around. They ain't pushing me around either, Sly. The cops took my wheelchair and demanded me a passenger stand up. How? I'm a 16-year-old paraplegic. Oh my God, Skyhopper. If you're not in Discord, bro, come in. We will chit chat about that and help you figure out how to bring forth a civil suit, bro. Listen, this is one thing that we really do, man. In Operation Wise Dome, I'm not an attorney. I can't represent you. I can't do any of that aspect, but collectively coming together, we research, and what we do is we help each other, which is what we can do. We're number one. Can't nobody tell us we can't. And we help people bring forth civil suits, their own federal civil suits, or their state tort claims, or fight their own cases, on the lower realm, municipal court, district, superiors, whatever the case may be. We even got people that are in the Supreme Court right now. And oh yeah, Section 1983, we get money in and cash. They don't want to touch it, boy. I put them on their ass. Better lose their badge, boy. Yeah, we coming in, they running with that knowledge and that wisdom. Yeah, better stop stunting, because we coming with that knowledge, baby. Yeah, the wisdom getting it. Wise don't win this thing, yeah, man. We hitting with the knowledge in the belt. People, people. Yep. We got the power all in the inherent in the people. I'm sorry, I had to, bro. I love this beat so bad, bro. Like so much. Oh, yeah, it's like whoa. Okay. So if you come into the Discord or you jump into Operation Wisdom, what you're going to find out is a collective body of people with over 630 members now, okay, that are coming together to bring forth their own civil suits. When I say homeboy Skyhopper, you ain't got to go get an attorney that's going to take 35, 33, percent of your well-deserved. Well, I won't even say deserved, because it's not deserved. You don't deserve it. It's an irreparable harm. You deserve to be respected. You deserve to be served. You deserve to be helped. You deserve to be cherished. You deserve to be, man. We have to bring forth back the comprehension that this life is sacred. We are not cherishing life. We have to cherish life again. We have to start cherishing just how beautiful it is to be here. We all notice and see how losing loved ones, like, we have to start cherishing life more. With that being said, y'all, I just want y'all to remember this is part 1. We're coming back with a notice and demand on the Kansas edition, okay? Don't get it wrong. I guarantee I could probably make this a Texas, Nebraska, California, Oklahoma, Nevada, Colorado, Florida, New York. I can make it any edition you want. This is a 57-page notice and demand as unconstitutionally applied with a judicial notice that is being brought forth into the court. The state prosecution don't want to fight these things. They know better than that. They know better than trying to say, you know what, I'm going to back up this cop and get myself involved in some ethics and prosecutorial violations. They're not going to do that, especially when you come to them on the forefront and speak with them before going into court, showing that, hey, I would like to operate in good faith and have a discussion around this with you before going into the court and making myself or you look like an ass. That's not the mission here. The mission is cooperation and respect, again, of our creator endowed rights that's on the forefront and the foundation of all of our existence. Those hundreds and thousands and millions of people that died on this soil to make sure that anybody that came here had said rights. I am you, and we are us, all a part of the great I am. I love you. I'll see y'all later. I got to get to work. Bye.